Michael Taylor as well as Lloyd Barnett, just to say that these are some of the people that make me just so proud to be Caribbean, and they serve as a reminder that here in the region we have some of the very best brains in the world. Not in the region, but not in the hemisphere, but in the entire world. And you'll agree and know when you hear what they have to say. Welcome also to those watching online, on Zoom, on YouTube. And just a reminder, if you know people who aren't here, who you actually think would enjoy the seminar, you can just drop them a message right now saying, hey, it's streaming live on Jet's YouTube channel, so they can tune in now and check that out as well. Just a couple of housekeeping notes for you. Because we're streaming live, we're going to ask you when it is you are, enjoying the coffee break and so on. Be very careful. Remember all the clinking, clinking, clinking. We don't want to hear that when people are doing their presentations, as it can be very distracting. Now, JET has also applied for accreditation from the General Legal Counsel. We're hoping that comes through, but because of that, you're going to be asked to complete 2 polls if you're in the Zoom room to verify your attendance. And as well, if you're on Zoom, we're asking that you use your correct name, no big bad lawyer kind of thing. Just rename yourself right now, please, with your correct name. And at the end of the seminar as well, everybody will be asked to fill out a form. You'll get a link if you're on Zoom or if you're watching in the YouTube chat, and there are QR codes on each table. And if none of that works for you, there'll still be paper forms, actually dead tree forms, that will be available that you can use as well. So at this point, let me welcome the CEO of JET, Dr. Teresa Rodriguez Mooney, to welcome you properly to the start of this seminar.
Thanks, Dion. Can you hear me? Okay. Senator Samudo, Minister without Portfolio in the Ministry of Economic Growth and Job Creation. Keynote speaker, Ms. Melinda Janke. Panelists, Dr. Lloyd Barnett, Professor Michael Taylor, and Mrs. Danielle Andrade Goff. Specially invited guests, Madam Moderator, Mrs. Dion Jackson Miller, JET staff, and those joining us via Zoom and YouTube. Welcome to Jamaica's first climate litigation seminar hosted by the Jamaica Environment Trust. A few months ago, wrapping up an interview on climate change, my 6-year-old looked at me and said, "Mom, when I grow up, I want to be like you and save the environment." I felt a mix of pride and sadness. Pride that at her age, she recognized that this is necessary work, but sadness because our children shouldn't have that millstone around their necks. The climate crisis is not their fault. We need urgent action so as to leave our children a world not devastated by our bad decisions, selfishness, and neglect. And this is why we use the term crisis, to emphasize the urgency and severity of the situation, to stress the significant and immediate threat climate change poses to the planet's ecosystems, human societies, and future generations. The climate crisis is a product of a system that extracts and exploits from the global majority for the benefit of a few. And it is urgent. All over the world, we are already experiencing the long predicted and severe impacts, including right here at home: unbearable heat, wildfires, unusually strong storms, extended dry periods, intense rainfall events, and sea level rise. The climate crisis has been dubbed the Great Equalizer because it transcends national borders and impacts everyone. But the concept of climate justice challenges this notion. Yes, climate change affects us all, but not equally. Using the analogy of my esteemed colleague, Jamaican-born UK climate activist Michaela Loach, imagine we're all in a big storm at sea together. Some of you are in a big, sturdy ship funded by colonial wealth, while others are in small, leaky canoes made more precarious by the same colonial exploitation which protects others. not everyone faces the same risks in the climate crisis because of historical and ongoing inequalities. And climate justice embodies the principle that climate change is not the great equalizer, but is in fact the great multiplier. Climate change exacerbates existing inequalities and vulnerabilities. It does not affect everyone equally. And moreover, climate change acknowledges the interconnectedness of social, economic, and environmental issues. It recognizes that systematic inequalities such as poverty, racism, and gender discrimination exacerbate vulnerability to climate change. And climate justice demands that we rectify this imbalance. It calls for equitable solutions that prioritize the needs and rights of those most affected by climate change, often those who did the least to cause it. This involves holding accountable those responsible for environmental harm, while ensuring access to clean water and sustainable livelihoods, just to name a few. And this is where climate litigation comes in. Informed by science, climate litigation empowers affected individuals and communities to take action to limit climate harm. It serves to hold governments and corporations accountable for their contributions to the climate emergency and their impacts on vulnerable communities, whether it involves challenging destructive projects, advocating for stronger environmental regulations, or seeking compensation for climate-related damages. The law is a powerful tool to drive positive change. Climate justice is about ensuring fairness, equity, and accountability in our response to the climate crisis. It is about safeguarding the rights and well-being of all people, particularly those most vulnerable to its impacts. So I hope today's presentations are enriching, insightful, and meaningful to all of you, and will present a call to action on this significant threat facing us all. Thank you.
Thank you so much, Teresa. And I see the minister just arriving, so I'll allow him to catch his breath while I invite Corneal Malek, Executive Director of True Cost Initiative, to come and bring greetings. Now, True Cost is one of the sponsors of the Jamaica Environment Trust and this seminar. And as well, we just always have to recognize that the people in the forefront of the fight are important, but those who stand quietly in the shadows and support are in fact just as important.
Thank you so much, Dion. Greetings, Senator and esteemed guests. As the founder and executive director of True Cost Initiative, one of the two sponsors who have the honor of making this event possible, I want to thank you so much for making space and for just the commitment and the intentionality around this event. Thank you so much. This is a first of its kind event in Jamaica, and it's really an honor to be a part of it. The true costs of the lack of climate justice, the lack of corporate accountability, and the lack of weak enforcement and the insufficient rule of law are threefold. There is a cost to land, there's a cost to life, and a cost to livelihood. I was asked by Teresa and Courtney to bring greetings on behalf of the sponsors and the partners, but I want to not only bring greetings, I want to tell you a story about my 5-year-old as well. I'm glad Teresa brought up her 6-year-old. Look, we're not the first to this climate litigation and strategic thinking about climate litigation, but Melinda and our panelists, under the graceful moderation of Dion, will walk us through the what, they're going to walk us through the how, and they're going to walk us through the why now. But your presence here is indicative of your commitment as my fellow lawyers to centering climate justice, centering climate litigation, and which is inherently strategic, and to meeting the existential crisis of our time. So my Jamaican Iranian daughter, we like to call her Geranian, said to me 2 weeks ago when she had her sports day, she said, "Mom, I don't have to come first, but I don't want to be last." And look, it's fine that we're not first. Jamaica is not going to be the first on this bandwagon of climate justice litigation. We're clearly not. But I'm really happy to report to her when I go back home that today I was in a room full of lawyers just like her mommy, who decided that, look, we're not first, but we're definitely not going to be last. Thank you.
Thank you so much. So Senator Matthew Samuda is a minister without portfolio in the Ministry of Economic Growth and Job Creation, but all of us in media just call him the Environment Minister. And he is behind the policy on the plastic ban, the styrofoam ban, and now the lunchbox ban. And he's also one of those always accessible and available for conversation and discussion on these important environmental issues. Senator?
Thank you, Dion, and good morning, everyone. I'm assuming protocol would have been established earlier, but it is indeed a pleasure to join you. The matter of justice and equity in the issue of climate change and in the issue of the environment generally has become far more topical. It is a session that has now found its way virtually permanently into the agenda of almost every environmental conference, every climate change conference that anyone attends. And that is for good reason. Ultimately, we all understand how we've gotten here. The economic model that we as human beings since the Industrial Revolution have pursued has cost us dearly. We have the impacts of significant environmental degradation in many categories of environmental management, and we have the most topical one and perhaps the most dangerous one of climate change in front of us now. Now, looking at the attendees, Dion, I don't need to explain to anyone here the impacts of the environmental degradation that we face, or certainly the impacts of climate change. But just to reiterate, because we had this discussion yesterday, the situation facing nations like Jamaica is existential. Between October 2022 and March 2023, Jamaica experienced its worst drought in recorded history, the 6th driest cumulative months ever. In February, where the drought peaked, you had virtually, in some cases, no rain at some rain stations. And in Kingston and St. Andrew, which is home to 1 million Jamaicans, 8% of your 30-year average rainfall having had reduced rainfall for 6 months previous. Now, that speaks to the issue of water, which virtually speaks to the issue of everything else. But the impacts that we're facing are already testing our adaptive capacity. It is why I believe the developing world, over the last 3 COP cycles, put as much focus on the issue of the loss and damage fund as it would have, which would have come to some form of maturity at the last COP. But if we really look at the language related to the loss and damage fund in the Paris Agreement, and we look at the, not just what's in the agreement, but what has been said about the agreement related to loss and damage, you see the particular struggle that developing nations and certainly communities within developing nations are going to have. There is no doubt that a loss and damage fund in many ways is intended to be a reparatory mechanism where there has been damage, where persons have suffered disproportionately. But if you look at the statements of the G7 membership, of the G20 membership, and certainly of your large corporate players that tend to be very active in this space, anything that appears to be reparatory is removed and rejected, and that, I believe, is at the core of the issue. There isn't a settled acknowledgement that the problem was created in this way by these persons, and they are the ones that must pay or must bear the brunt of the repair work. And that in and of itself is a challenge, because you'll go into the mitigation session and you start with your buzzwords, your 1.5 to stay alive. And you get into further buzzwords of just transition, and everyone should transition, as opposed to nations that emit more transitioning faster versus dark countries like Jamaica that really have very little emissions, either per capita or in totality, transitioning at the same pace as everyone. That's, I think, at the core of some of the issues, because there still isn't an acceptance within the developed world that they have disproportionately caused the problem. Now, scientists and those who are certainly have their finger on the pulse of this issue, like Prof. Taylor, can state definitively that they have caused the issue. We have sufficient science to say what has caused the particular rate of climate change, but we haven't transitioned that science into political action. And that political action is unlikely, I believe, to come globally, or the sort of political action that's required, without a far more litigious developing world. That's unfortunate, but I believe where we are. The commitments under the climate change agreements and addendum to the Paris Agreement have not been met. The pledge sessions at these conferences are farcical, and admittedly that's when I use time for bilateral meetings, because they're not met. And it's because, fundamentally, the same discussions that I think hold back the members of the developed world on the issue of reparations, hold them back on climate justice. 20 and 30-year-old taxpayer in the developed world does not make the connection between what has gone before them and where they are, and why their tax dollars should fund a reparatory process. That's at the core of it, and that is a political challenge that leaders in the developed world face. It's not a discussion that, no matter how you articulate it, is easy to be absorbed by their voters, by their taxpayers, by their citizens. That is the challenge. So the rightness or wrongness of it is compromised by that reality. But there is obvious precedent for the developing world, for nations which are wronged, for communities which are impacted negatively by commercial activity or by political decisions, to exact justice by way of established legal systems. I am obviously not qualified to speak to those legal systems, and I'm looking forward to listening to the varying conversations that will take place as we seek to galvanize an approach that can be taken to achieve this, because it really won't happen without it. That is the reality. But the other challenge that the developing world must face, and that I would love to hear for as long as I'm able to stay this morning, come out, is the impact of the varying agreements and treaties that we are party to. Some ratified, some not. You see, the treaties and the agreements that generally are put through the COP process, whether the COP 15s or the COP 28s, whether it is the BBNJ, whether it is the Paris Agreement or the SCASO Agreement or SPA Protocol, many of these things are designed with no correlation to the capacity of the bureaucracy in developing nations. They are well-intentioned. If implemented, they achieve what you wish, but they're not designed with any correlation to the capacity of developing nations. And that, in and of itself, creates a challenge, especially when you contemplate what these agreements do, especially as the developing world tries to lead the way in being nature positive and trying to put nature at the center of what it does, and it is being called on, certainly with your land use issues, to take leadership, because it is the underdeveloped, so to speak, from an economic perspective, parts of the world that do function almost as the earth's lungs. These agreements are well-intentioned and generally agreed upon. Now, what you have right across the developing world, and I was doing some reading over the last few days, is you have those who have not yet ratified and those who have ratified quite a few, not just Escazu, who, when you speak to, certainly when I speak to colleague environment ministers, they say absolutely, we 100% wholeheartedly support it. But there's a term or there's a demand for something that we simply cannot meet. Now, as I've found and I've had explained to me several times as we go through the legislative amendment process by the CPC, by the AG, by the SG, by LRD, they're always, I find culturally, for whether good or bad reason, but culturally, as I've found, there's always a lot of wariness when you have rules in legislation that aren't set up in a particular way that applies to everyone. Different categories for different folks leaves them very apprehensive. So one of the challenges you have with something like the Escazu agreement, and though we're moving to have that completed, is really the commitments that you make in the ATI agreement, in the ATI law, sorry. And everyone in here who I know is active in civil society and active certainly in the media will attest that there is something in legislation, but in practice it is not achieved because the bureaucratic capacity simply is not there to answer the questions in a time frame. And if one was to add the budget requirement that would allow these answers to come in the time frame, not just that the law contemplates now, but that further agreements, not just Escazu, others that we absolutely should adhere to, should ratify, the budget cost associated with being able to answer questions at the particular rate that queries come would be significant. So this isn't to be taken in any way as a step back or drawback from the commitment to transparency, but it is something that I believe needs to be contemplated, because with all of your needs as a developing nation, where does that priority lie? Where does the priority lie with issues such as data protection, which is now also finding itself into several environmental treaties in terms of how we will take private sector data and share internationally for international reporting. That is coming up. That is a facet of the discussions on what's expected to be a groundbreaking plastics treaty. And when we look at our Data Protection Act, for instance, that the private sector right across, large and small, will tell you is draconian because of the need for data officers, etc. We can see the challenge coming, because one of the factors or one of the expectations I have for that treaty is that it will put even more focus on data protection. So whereas Jamaica will indeed meet its plastics targets within the time frame, the Data Protection Act and the ATI Act will also cause some issues with us being able to ratify in that time frame. But ladies and gentlemen, I'm here to listen far more than I am here to speak this morning. I do thank you for the invitation. I think it is very timely and very important that this issue be examined, because the environmental ambitions that we state and when we're called on to increase our ambition will only come with economic support, with political will, but with international support that will no doubt not happen without litigation. So I look forward to the discussions. Thank you.
Thank you so much, Minister. You know, I think he was looking over my shoulder, because I literally, if you look at my paper, I had a note here to remind the audience that Jamaica has signed but not ratified the Escazu Agreement, which is a regional agreement on access to environmental information, environmental justice, and participation in national decision making. And to say hint, hint, Minister. So, so he got ahead of us on that. So if you're just joining us online, on Zoom or on YouTube, welcome to you. We invite you as we go along to drop the questions that you have in the various chats. We have someone on monitoring the chat, and we will ask them at appropriate times. Now, our keynote speaker for this morning is extremely impressive, and I'm going to invite the legal officer of JET, the Jamaica Environment Trust, Courtney Dixon, to come up and introduce her to you. And in the meantime, remember, jot down all your questions and tell people, tune in on the YouTube channel because you can watch there.
Good morning, everyone. Miss Melinda Janke is the 2023 winner of the prestigious Commonwealth Lawyers Conference Rule of Law Award for her work to uphold the rule of law in Guyana and internationally. Her legal career began in the City of London. She later moved in-house to a major oil company, also in London. She was a partner in a law firm in Guyana before transitioning to consultancy. She has worked on controversial gas and oil pipelines internationally. She currently leads litigation against the fossil fuel industry and dangerous deep water drilling offshore Guyana. Melinda's legal advocacy extends beyond borders, having worked in projects and advised governments and organizations across Europe, Asia, the Americas, and Africa. Her clients range from multinational corporations to indigenous tribes and international financial institutions, demonstrating her versatility and commitment to justice. In 2023, Ms. Janke's accomplishments included notable legal victories, such as securing unprecedented court rulings against big oil companies and governmental agencies, ensuring transparency and accountability in environmental matters and championing indigenous land rights. Her dedication to environmental protection and indigenous rights is further exemplified by her co-founding of Lawyers Are Responsible, a group of prominent lawyers taking action in solidarity with those on the front line of the climate and ecological crisis. Ms. Janke's contributions extend beyond the courtroom with a prolific record of legal publications and non-legal writings on topics ranging from indigenous rights to environmental conservation. With a formidable educational background, including degrees from prestigious institutions like the University of Oxford and University College London, Ms. Janke continues to be a leading voice in the global legal community, advocating for the rule of law, environmental stewardship, and social justice. Please welcome Ms. Janke.
Good morning. I'm delighted to be back in beautiful Jamaica and to be able to spend some time with you. Thank you all for being here, and thank you for your gracious remarks, Courtney. The Senator is a hard act to follow, but I will do my best. Should Caribbean lawyers be getting ready for climate change litigation? I hope that by the end of this keynote, you'll be more interested in climate change litigation, better placed to evaluate how and even whether climate change litigation can help to remove the existential threat faced by the Caribbean. I hope you might think about this differently. Now, as Lord Steyn said in the Crown against the Secretary of State ex parte daily, in law, context is everything. What's the context for climate change litigation today? I think we all know what that is. Greenhouse gas pollution, mainly carbon dioxide, has destroyed the Earth's energy balance. The Earth is overheating. Sea levels are rising. The polar caps are melting. The global climate system is breaking down. That last harm is what is euphemistically called climate change. Now, we know greenhouse gas is produced by burning fossil fuels, and its harms were accurately predicted in the 1970s and the 1980s by people with unchallengeable expertise, the fossil fuel industry. An internal Exxon study in 1979 said that fossil fuel consumption would cause dramatic climate effects, and the potential problem was both great and urgent. 1979, Exxon. The American Petroleum Institute said significant temperature changes are almost certain to occur by 2000, and these could bring about climate changes, and so on. If people ask you whether you believe in climate change, send them to the fossil fuel industry research. Don't waste time. Context is also economic. There is an energy market. Markets depend on competition. In The Road to Serfdom, Friedrich Hayek warned that the system of competition depends on the property owner being able to benefit from the useful services rendered by his property and suffering for all the damage caused to others by its use. But today, it's not the polluters who suffer. The price of oil and gas does not include the cost in human suffering and the destruction of nature. In The Economics of Climate Change, Nick Stern, a former World Bank economist, concluded that climate change is the biggest market failure the world has ever known. So in this context, a legal industry has grown up to protect the climate. But what is climate change litigation? The handbook on climate change litigation says, is litigation where a claimant, a defendant, raises climate change arguments, or litigation on mitigation or adaptation, including litigation against fossil fuel intensive projects. And there are thousands of cases: constitutional, environmental, human rights, indigenous, corporate, consumer protection, etc. We can only look at a few, and in this keynote, I will discuss cases involving mitigation, compensation, and investors. And don't worry about writing down the cases. I'm going to give a list of them to the Jamaican Environmental Trust, and the paper is also going to be published later on. Now, a note on terminology. When the cases say emissions, I will say emissions, but otherwise, I'm going to say pollution and polluters. Let's talk truth to power, and let's stop the lies about what is going on this planet. Now, only one case involves a carbon sink. It's the biggest climate change case in the world. It's also a Caribbean case. Good place to start. Thomas and de Freitas against the Attorney General of Guyana and Exxon Guyana is a constitution claim in the High Court of Guyana, and I represent the applicants with co-counsel. Article 149J of the Guyana's constitution says that everyone has the right to an environment that is not harmful to his or her health or well-being, and it says the state shall protect the environment for the benefit of present and future generations through reasonable legislative measures designed to prevent pollution and environmental degradation, promote conservation, secure sustainable development, and so on. Under Article 149J, the state has a negative legal duty: don't make the environment more harmful to human health and well-being, and a positive legal duty: take reasonable measures. Now, the applicants say the government breached their right to a healthy environment by authorizing ExxonMobil's petroleum operations, because inevitably that will produce greenhouse gas pollution, which will exacerbate global overheating and ocean acidification. This is a climate change case, but it's framed as a pollution case. Now, ExxonMobil Guyana denies these harms from greenhouse gas pollution. They say, bring experts to prove this. And Dr. Thomas has replied, and in his affidavit in response, he says, the facts of greenhouse gas pollution and the impacts such as global warming and ocean acidification are well-established facts. And he says, this is on par with saying that is a matter of scientific opinion, not fact, whether the earth is round, and that I must carry out a disproportionately expensive exercise to prove to the court that we are not living on a flat earth. Now, in the city of Oakland and people of California against BP, Chevron, Exxon, Shell, the usual suspects, the judge dealt with such arguments neatly. He required the oil companies to provide a tutorial on the science of climate change. And then his decision set out the science, and he said, the issue is not over science. All parties agree that fossil fuels have led to global warming and ocean rise and will continue to do so, and that eventually the navigable waters of the United States will intrude upon Oakland and San Francisco. All parties agree. So Exxon accepts global warming in a court in the United States, but denies it in a court in Guyana. Now the remedies. Thomas and de Freitas ask for various declarations, including a declaration that greenhouse gas pollution will make the environment more harmful to their health and well-being and is a violation of Article 149J. Declarations are powerful remedies because, as Zamir and Wolf point out in their excellent work on declarations, a declaration pronounces upon a legal relationship, but it doesn't contain an order which can be enforced. Nevertheless, in the Crown against Secretary of State for Transport, ex parte factite, Lord Bridge of Harwich said, a declaration of right made in proceedings against the Crown is invariably respected and no injunction is required. We would therefore rely on the constitutional principle that the executive will comply with a declaration. Now, why is Thomas and de Freitas the biggest climate change case in the world? Because of the sheer scale of the pollution that is being challenged. ExxonMobil says it's found 11 billion barrels of oil, and burning that would produce 4.75 billion tons of carbon dioxide. Guyana is also estimated to have between 7 trillion and 95 trillion cubic feet of fossil gas. Burning that would bring millions more tons of greenhouse gas pollution. And in comparison, the landmark Urgenda case in the Netherlands dealt with 56 million tons of pollution, the Australian case of Sharma with 100 million, and the French case called the case of the century, Notre Affaire à Tout, against France, originally related to 62 million tons, but was reduced on appeal to 15 million. So Thomas and de Freitas really is the biggest climate change case in the world, and a lot hangs on the decisions and the court. Now, I want to turn to another constitution case held in Montana, which has a result. This case challenged the Montana law, which forbid the state and its agents from considering the impacts of greenhouse gas pollution or climate change in their environmental reviews. Montana's constitution says that all persons have certain inalienable rights, including the right to a healthy environment, and that the state and each person shall maintain and improve a clean and healthful environment for present and future generations. The case was brought by 16 young people between the ages of 2 and 18. And I think here is something that we need to think about. Where are the youth of the Caribbean in facing this existential threat? The judge found that as children and youth, they are disproportionately harmed by fossil fuel impacts and fossil fuel pollution. The brains of children and young are not fully developed until around 25. All children, even those who don't have pre-existing conditions or illnesses, are still a population that is sensitive to climate change because their bodies and minds are developing. And those findings hold good for children and young people everywhere, including children and young people in the Caribbean. Climate change impacts are global. Nobody is going to escape. So the judge said the right to a clean and healthful environment is complemented by an affirmative duty on the government to take active steps to realize this right. But they're ignoring greenhouse gas pollution and its impacts, and the judge held that the law was unconstitutional. In contrast, Norwegian judges have privileged oil over the right to a healthy environment. Article 1112 of the Norwegian Constitution says that every person has the right to an environment that is conducive to health and a natural environment where productivity and diversity are maintained. Notice that, productivity and diversity, not much respect in there for nature. Natural resources also have to be managed to safeguard the right for future generations, and there is a right to information. Norway awarded 10 production licenses, and in Greenpeace Norway and the government of Norway, the Supreme Court held there was no violation of Article 112. They seemed to think that the real issue was the future emissions if the oil was burned, and they seemed to think that the politicians could deal with that. There is a predictable sequel. In 3 other oil fields, the minister approved production, and in Greenpeace against the Minister of Energy, Greenpeace said the minister's decisions were illegal because the impact assessments did not take into account emissions from combustion of the gas produced. And the Oslo District Court agreed, and in January 2024 ruled that the decisions to allow the production were invalid and granted temporary injunctions. But they dismissed claims based on the European Convention on Human Rights. I'll turn now to the landmark mitigation case, Urgenda and the Netherlands. Urgenda claimed that greenhouse gas from the Netherlands was contributing to dangerous climate change case, and they said that the state is the sovereign power responsible for those emissions and under national and international law must cut emissions by between 25 to 40%. The Hague District Court agreed and ordered the Dutch state to cut emissions so they would be at least 25% lower at the end of 2020 compared to 1990, and the decision was upheld by the Court of Appeal and by the Supreme Court. The Dutch said, well, you can't really say we're one of the causes of imminent climate change because we don't actually emit greenhouse gases. The court rejected that, and they said the state has the power to control the collective Dutch emission level and does control it, and that it signed the United Nations Framework Climate Change Convention and the Kyoto Protocol and accepted the obligation to reduce this emission level as much as needed to prevent dangerous climate change. States have a responsibility. Now, the Dutch government says they reached their 2020 emissions target, and that's a great success. Or is it? If we're serious about climate change litigation, we have to assess it bearing in mind the context, the existential threat from fossil fuels. And governments have recognized this danger in the UNFCCC, Kyoto Protocol, the Paris Agreement, the COPs around these things. The judiciary has recognized the harm to life on Earth. For example, in Ashgar Ligari and the Federation of Pakistan, the court said, climate change is a defining challenge of our time and has led to dramatic alterations in our planet's climate system. For Pakistan, these climatic variations have resulted in heavy floods and droughts, raising serious concerns about water and food security. On a legal and constitution plane, this is clarion call for the protection of fundamental rights of the citizens of Pakistan, in particular, the vulnerable and weak segments of the society who are unable to approach this court. Just 7 years later, global overheating caused excess rainfall and melted glaciers. Pakistan suffered catastrophic flooding that covered a third of the country, killed more than 1,700 people and more than 1 million animals, and caused $15 billion worth of damage. Pakistan contributes less than 1% of greenhouse gas pollution. The real culprits are the historic polluters. Now, the safe limit for greenhouse gas pollution in the atmosphere is supposedly 350 parts per million. It's now at 420 parts per million. There's no room for any more greenhouse gas pollution. The Netherlands is a massive polluter even now. Should the court have said to the Netherlands, stop that pollution as fast as possible? And if the answer is yes, doesn't that apply logically to every single country, even carbon sink Guyana? Because pollution is pollution, no matter where it's coming from. Is it possible to stop? Let me give you a clue from the biggest polluter of them all, historically and currently, the United States of America. The United States Energy Department says that solar energy is the most abundant energy resource on Earth. They say 173,000 terawatts of solar energy strikes the Earth continuously, and they say that's more than 10,000 times the world's total energy use. We don't have an energy crisis. We have a political and legal crisis. And by the way, the sun is going to shine every day for another few billion years. So what about the actual polluters? How to stop them? In the Wild Coast and others, against the Minister of Natural Resources and Energy and Shell and others, South African communities on the front line and NGOs filed a case against the ministers and Shell, challenging exploration rights and renewals that were granted to Shell and associated entities. Shell wanted to do seismic surveys under its exploration rights. They fire air guns, and then they analyze the resulting sound waves to find oil. The sound is so loud, it can kill whales. Now, the court held that these decisions for the exploration rights were illegals. So the communities had stopped the seismic survey, and this is a huge victory. Let's look at how they did it. The court said there was procedural unfairness in the public consultations. The affected communities were not consulted. The court said the top-down approach, whereby kings and monarchs are consulted on the basis that they spoke for all their subjects, is a thing of the past, which finds no space in a constitutional democracy. Talk to the people. There was a dispute between the experts for the communities and Shell's experts over the impacts on wildlife. The court said the minister should have applied the precautionary principle. There are some risks we should not take. The communities said that the minister had failed to consider their spiritual and cultural rights and their rights to livelihoods. Others said the decision maker had not properly considered climate change. The court upheld the community's arguments and struck down the exploration. And this judgment is very progressive in acknowledging community beliefs about the sea as a sacred place where ancestors dwell, and ruling that that relationship had to be taken into account. Now, in Milieu Défensi and Shell, Milieu Défensi used similar arguments to Agenda, but applied them to Shell and said that Shell had an obligation under the Dutch Civil Code to contribute to the prevention of dangerous climate change. He's still talking about preventing something that is already here. Now, the court agreed and said Shell must reduce its emissions by at least 45% at the end of 2030 relative to 2019 levels. Shell said requiring them to cut the emissions would lead to unfair competition and a disruption of the level playing field on the oil and gas market. Let's consider Shell's claim. The IMF calculated that in 2022, governments subsidized the fossil fuel industry by $7.1 trillion US. So why not remove the $7.1 trillion in subsidies and give Shell and the rest of the polluters a level playing field? Why not let the market do its job and put these polluters out of business? Where are the competition lawyers and where are the WTO lawyers? Shell filed a statement of appeal running to 206 pages. They say, emissions reductions cannot be considered in isolation from the broader energy security and sustainable economic development considerations that are critical in and inextricably linked to the energy transition. Does energy security come from an oil and gas industry whose business model depends on destroying the earth? Or does energy security come from safe, clean, cheap, renewable energy? In effect, Shell is saying they have the right to pollute the planet, even if it means that people, animals, forests, marine life die. And we know where those people, animals, forests, and marine life are located. Energy transition, the polluters are the biggest obstacle. In Rhode Island, against Chevron, BP, Exxon, Shell, and 17 other of the polluters, the judge in an intermediate ruling said, defendants understood the consequences defendants understood the consequences of their activity decades ago, when transitioning from fossil fuels to renewable sources of energy would have saved a world of trouble. But instead of sounding the alarm, defendants went out of their way to becloud the emerging scientific consensus and further delay changes, however existentially necessary, because they would in any way interfere with their multi-billion-dollar profits. Now, in Gabčíkovo-Nagymaros, in the International Court of Justice, Judge Guramantri described sustainable development as a growing awareness of the risks to present and future generations and the need to reconcile economic development with protection of the environment, and this concept is now part of customary international law. So Shell is talking about sustainable development. What does that look like for Shell? On the 28th of February 2024, the British MP Clive Lewis told the Westminster Parliament, Shell is responsible for some of the most brutal, violent, and repressive actions by a company, in this case against communities in the Niger Delta. This includes complicity in the execution of the Ogoni 9, including writer and human rights activist Ken Saro-Wiwa. Shell's exit from the Niger Delta could set a precedent for other British multinationals operating in the global south that may be seeking to evade responsibility for environmental destruction, leaving communities with little recourse to justice. That's it in a nutshell. Now, the Milieu Défense Shell case has an interesting sequel. Shell moved its headquarters out of the Netherlands to the UK, which is why their proposed exit from the Niger Delta came up in the British Parliament. And Client Earth brought a case in England claiming that Shell's directors had to take steps to comply with the judgment. They put... Thank you. Okay. Me. All right, because I can holler. They put in evidence a letter from a Dutch lawyer saying that the order meant Shell was immediately obligated to take measures to reduce its emissions, and if they didn't do so within a reasonable period of time, Milieu Défense could enforce the judgment. Now, the judge read the Dutch judgment, and he pointed out, look, it says Shell has total freedom to comply with its reduction obligations as it sees fit. And your evidence, Client Earth, did not deal with the totality of the Dutch judgment. Client Earth's response was that the judge should not have looked at the Dutch judgment, but should have taken Client Earth's evidence at face value and without further inquiry. The judge said the court could not take passive and uncritical approach to evidence, particularly when it was faced with a passage that seemed to cut across Client Earth's case as directly as that one did, and he refused the application. Why am I talking about this case? Because it is a warning about trying to use company law inappropriately. Company law can be used against the fossil fuel industry, but it can't be done in this way. I started with the Caribbean, and I'd like to go back to the Caribbean. The Guyana litigation concerns Exxon's petroleum production from dangerous deep-water drilling offshore Guyana. It has been categorized by some as climate change litigation because it deals with massive fossil fuel expansion. And apart from Thomas and De Freitas, all of the other cases are based on the rule of law, and I act with co-counsel for all of the applicants. In Collins and White against the Environmental Protection Agency in Exxon Guyana, in an internationally acclaimed decision on the 3rd of May 2023, the judge ruled that Exxon Guyana had to provide an unlimited parent company guarantee to cover all costs of an oil spill. The judge also required Exxon to provide environmental liability insurance, because you see, the insurance that Exxon Guyana had originally provided named Egypt, not Guyana. Exxon and the EPA said they were working out a $2 billion guarantee. The judge said, it is simply not open to the permit holder to say it is engaged in a frolic of its own, aided and abetted by the EPA, to unilaterally, arbitrarily, and unlawfully cap its unlimited liability and financial assurance. Oil spills are expensive to clean up. The Macondo well blowout cost BP over $70 billion to clean up. This is Exxon's map. It shows Guyana's oil on Jamaica's coast. You might want to do something about that. Exxon has appealed. The unlimited parent company guarantee protects EPA and Guyana government. The EPA has appealed. The Attorney General of Guyana has applied to join the case to oppose the order for the guarantee in favor of the government of Guyana. We opposed his application. The Court of Appeal rejected the joinder. The Attorney General has appealed to the Caribbean Court of Justice. Exxon and the EPA applied for a stay of the order. A judge in the Court of Appeal in Guyana granted a stay of the order for the unlimited parent company guarantee and the insurance. A few weeks after the stay was granted, there was a report in the press that John Hess had publicly said that before the stay was granted, President Ali assured him that the judge would grant the stay. The following day, the press made public a recording which they said was John Hess making those statements. As a condition of the stay, the judge ordered Exxon Guyana to lodge a $2 billion guarantee. We asked to see it. Exxon Guyana say they lodged it with the EPA. The EPA and Exxon Guyana refused to produce this $2 billion guarantee. We applied to the judge for an order to make them produce it. The judge ruled that he did not have jurisdiction to order either Exxon Guyana or the EPA to produce the guarantee which he had ordered Exxon Guyana to lodge. We have appealed against that ruling to the full bench of the Court of Appeal, which is where the case is. In his affidavit, the applicant Collins has said that every day poses a great risk to Guyana from the potential liability of a well blowout or an oil spill offshore Guyana, and that it also threatens the Caribbean. In Thomas against EPA and Exxon, the applicant was successful in cutting Exxon's environmental permits down from 20 plus years to 5 years, and that means that Exxon has to apply for a new permit every 5 years. In Dean Hughes and Radzig against EPA and Exxon and the Attorney General, the judge said that the EPA acted unlawfully when it granted an environmental permit to Exxon for a pipeline on a proposed gas-to-shore project. Remember those trillions of feet of gas. But the judge declined to grant a remedy because so much money has been spent, and that case is on appeal. The Attorney General claimed that the applicants were obstructionists. The judge held that they were public benefactors. Now, in Gaskin and the Minister of the Natural Resources, against the Minister of Natural Resources and the Environment and Esso, Hess and CNOC, the applicant said the minister acted unlawfully when he granted a petroleum production license to Hess and CNOC because those two don't have environmental permits. The case was very recently heard by the Caribbean Court of Justice, and we await their decision. In Henry Naguir Torrington against EPA and Exxon, the applicant said the EPA acted unlawfully by altering Exxon's environmental permit to allow Exxon to flare gas instead of re-injecting it. And they asked the judge to grant orders also enforcing provisions of the environmental permit. After 17 and a half months, the judge ruled against the applicants, and that case is on appeal. In Henry Radzig against EPA and Exxon, the applicant said, if you're going to apply for a new permit, you need a new or updated environmental impact assessment, and the judge dismissed that argument, and I'm awaiting instructions from the clients whether there will be an appeal. Naguir and EPA was recently filed and asks for orders prohibiting the EPA from granting a new permit to Exxon unless the financial assurance is in place, and that means insurance and a guarantee. The cases in Guyana and the thousands of cases making their way through the courts in jurisdictions across the world demonstrate that slowing down and halting greenhouse gas pollution is critical to life, the environment, and also the economy. But what about compensation for harms caused by greenhouse gas pollution? What's happened to the polluter pay principles? In the United States, there's an interesting line of cases brought by states and cities: Rhode Island, Minnesota, Connecticut, Delaware, New Jersey, Massachusetts, Vermont, California, District of Columbia, Baltimore, San Francisco, Honolulu, New York City, and many others against the big polluters, ExxonMobil, Shell, Chevron, BP, etc., to make them pay for the damage. And all of these cases use a combination of legal grounds, including grounds such as public nuisance, private nuisance, strict liability, negligent failure to warn the public of the risks posed by their products, impairment of the public trust, trespass through flooding, saltwater intrusion, deceptive trade practices, greenwashing, suppression of material facts, breach of consumer legislation, misrepresentation, and so on. I will just give you a few examples. The state of Minnesota accuses Exxon and the American Petroleum Institute, Koch Industries, and Flint Hills of a civil conspiracy to mislead the public, fraud and misrepresentation, and asks that they disgorge all profits made as a result of their unlawful conduct. Baltimore says the carbon majors knew 50 years ago that using their products warms the planet and causes climate change, and Baltimore has experienced significant sea level rise and associated impacts over the last half-century attributable to the carbon majors. They're claiming damages based on public nuisance, private nuisance, strict liability, trespass, and consumer protection. Honolulu says that the carbon majors concealed information from the public about the impacts of fossil fuels and conducted a public relations campaign to discredit the science. Chevron has filed a 72-page answer to Honolulu in which they say, any allegation that the Chevron defendants deceived or misled federal, state, or international regulators or the public about the potential impacts of increased greenhouse gases on the climate is belied by a historical record replete with public information, including science reporting, international, federal, and local policy discussions and lawmaking, and national and local media coverage. And despite this widespread knowledge of the potential adverse climate impacts related to increased carbon dioxide in the atmosphere, the United States, like the rest of the world, has continued to rely on and promote oil and gas for its energy supply. I think what Chevron is trying to argue is that it doesn't matter what they said, because the public and the government knew about the impacts of greenhouse gas based on all that public coverage and reports. Now, the Commonwealth of Massachusetts has sued Exxon, claiming that Exxon distorted the market for energy products and made materially false and misleading statements to Massachusetts investors about the proxy cost of carbon. Interestingly, they cite Guyana as an example where Exxon misled investors. Deception by Exxon in relation to Guyana is not unknown. In Collins and White and the EPA and ESSO, the court held that Exxon Guyana engaged in a disingenuous attempt which was calculated to deceive when it sought to dilute its liabilities and settled obligations. There are two other investor cases which deserve attention. One is the Client Earth case I mentioned earlier, and the other is another Exxon case, but this time Exxon is suing the investor. In Client Earth and Shell, Client Earth sought permission to bring a derivative claim on the grounds that the directors were in breach of their duties in relation to climate risk. The judge rejected their claim on various grounds. He said the duties created by Client Earth were too vague and incapable of constituting enforceable public duties. He said Client Earth ignored the fact that the directors balanced competing considerations, not just the climate. And he said he could not rely on Client Earth's evidence. He was not satisfied also that Client Earth was acting in good faith, but rather had adopted a single-minded focus on the imposition of its views and those of its supporters as the right strategy for dealing with climate risk. The problem with this kind of shareholder activism is that it is incompatible with the business model of the company that makes money from oil and gas. You can't argue that you're therefore you're bringing these actions in the best interests of the company, which is a requirement. Cutting pollution means putting the company out of business. And while that might be a good thing for the planet, it's not in the best interests of the company to put the company out of business and destroy shareholder value. So it's not going to work. And this is precisely the basis of ExxonMobil's case against two activist shareholders, Arjuna Capital and Follow This, who had put forward resolutions for ExxonMobil to accelerate the pace in cutting its emissions. Exxon says that would mean changing the nature of its business or going out of business entirely. Yes. ExxonMobil, Shell, BP, and the other oil companies can only make money by polluting the earth with greenhouse gas. Stopping greenhouse gas pollution means putting the fossil fuel industry out of business. I'm not going to insult your intelligence with the fossil fuel industry's fantasies of unproven technology, including the fashion for carbon capture and storage. The technology for removing carbon from the atmosphere is billions of years old, and it's called photosynthesis. Guyana's forests remove approximately 154 million tons of carbon dioxide every year, according to government figures. That's almost certainly an overly optimistic estimate, given forest degradation and destruction and the wildfires that are right now ravaging the south of Guyana. The government, nevertheless, has entered into arrangements for carbon credits as a way of enabling polluters to offset their pollution. I've written to the President informing him that, in my opinion, these arrangements are illegal because they violate the property rights of Guyana's Amerindian communities. I'm now going to turn to international law because I've been asked to mention the advisory opinions. But first, bear in mind where international law came from. As Professor Craven wrote in the Oxford Handbook of the History of International Law, to speak today of the colonial origins of international law is arguably no longer a standpoint of dissent or of radical revisionism, but one which is situated in the center ground of accounts of international legal history. Under international law, Europe's civilizing mission justified European slaughter of the peoples of Africa, Asia, Australia, and the Americas, and the enslavement of our ancestors. When colonialism was no longer legal, the civilizing mission was transmuted into development, in which former colonies are branded as developing countries that can never catch up with the so-called developed countries. There is an inbuilt assumption of superiority and leadership in international law. The Paris Agreement says that developed countries shall continue taking the lead. What? The big historic polluters? Are we going to allow the so-called developed countries to lead us to oblivion? Or are the real leaders the people who still have nature, who still have biodiversity, who still have forests? Isn't Guyana, for example, a climate leader as a carbon sink? Now, in 2023, the General Assembly's resolution for the ICJ to provide an advisory opinion on climate change says, having particular regard to the Charter of the UN, the International Covenant on Civil and Political Rights, Covenant on Economic, Social and Cultural Rights, the Framework Convention on Climate Change, Paris Agreement, United Nations Convention on the Law of the Sea, the duty of due diligence, the rights in the Universal Declaration of Human Rights, principle of prevention of significant harm, and the duty to protect and preserve the environment, what are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations? And what are the legal consequences under these obligations for states where they, by their acts and omissions, have caused significant harm to the climate system and other parts of the environment with respect to states, including, in particular, small island development states, which, due to their geographical circumstances and level of development, are injured or specifically affected by or vulnerable to the adverse effects of climate change, and peoples and individuals of the present and future generations affected by adverse effects of climate change. They're still talking about climate change. They haven't said pollution. This is why I say speak truth to power. We have a pollution problem, and it is solved by making the polluter pay. Now, this request looks very progressive. It puts humans, not the economy, at the center. It talks about present and future generations. It's moved forward from the dreariness of development. But look again. This request is anthropocentric. It refers to the environment, but there's no recognition of non-human life. It ignores the Convention on Biological Diversity, which opens with the words, conscious of the intrinsic value of biological diversity. In other words, nature, each plant, each animal, each relationship, which is part of an ecosystem, has a value in itself, irrespective of whether that nature is useful to humans. And it ignores legal developments in sovereign states that have extended personhood to nature. I'm looking at my thing, and I am going to run out of time. So I'm not going to take you through all of this now, because I don't want to overrun. We need time for the discussion. I'm simply going to refer to the line of legal cases which extend personhood to nature: Ecuador, Canada, Australia, New Zealand, where rivers have been granted the status of living entities. And this comes out of the relationship that indigenous peoples have had with their lands and the animals and plants they share their lands with. And why is this relevant? Suppose the judges, instead of approaching this from the straitjacket of anthropocentric concerns, which is what has brought us to today's crisis, suppose they thought about this from the perspective of nature. Now, I'm going to close off now, and I'm going to leave the discussion on ITLOS for perhaps the questions. As I come to the end, you may have noticed that I have not once said justice or mentioned a just transition. Every day, people and our more than human companions are dying and suffering because of fossil fuels. It's too late for a just transition. Justice and the fossil fuel industry are mutually exclusive. If you have one, you cannot have the other. There are no arguments to reconcile justice and fossil fuel production. Climate change litigation is a tool. Justice is why we use it. Justice is what requires us to think differently and requires us as lawyers to create new legal tools to halt the pollution, to make the polluters pay, to make them pay to remove their pollution, and to make them pay compensation for the suffering they have caused. Justice is what we do. Thank you.
Okay, wow. Okay, so we have about 15 minutes for questions, and just want to remind our online participants and viewers that you can drop your questions into the chat. Okay, let me not move. That you can drop your questions into the chat. We have a few coming in already. So let me start. Hold on, just give me a minute here, folks. Okay, so let me start with a question while people in the room get ready. Here's a question from Nicole Foster. Do you see the current advisory opinions assisting with domestic climate litigation efforts? So that's the advisory opinion before the International Court of Justice as well as the IAC-THR.
Thank you. I think that's a really good question, and it's one that has been worrying me, actually, because so much of this is going to depend on what the states put in front of the judges. And so much of that may well be dominated by the states that are currently the ones that are causing the problem, the big fossil fuel producers and users, because this is what underpins the lifestyle of the global north. So it's critical that people in the global south lobby their governments and make sure that what goes in to the ICJ isn't the same old responding to what the global north has already done, but looks at this from a completely different perspective.
Okay, Nicole, just another question there from, well, before I move on to the other question from Nicole, to your knowledge, Ms. Janke, is has Jamaica been, we have heard that Jamaica is working on that, and I was actually going to ask the minister to contribute, but I think he's jumped out, he's stepped out. Do you know if the Jamaican contribution is coming in or has come in for that?
I don't know, but I would think almost certainly. And if we look at the request to the International Tribunal on the Law of the Sea, which is very interesting because that's been brought jointly by a Caribbean country, Antigua and Barbuda, and by Tuvalu. And I think they're going to bring a different perspective because remember the presentation by the Minister of Foreign Affairs from Tuvalu where he was thigh deep in water. What's happening is that some places are going to disappear. And what happens to the people who live there? Indigenous peoples are connected to that earth, that land, that is where the ancestors are. These places have meaning. You can't simply say, well, now you have to move, because that destroys who they are, that destroys their spiritual connections. And these things need to be said to the International Court of Justice, and they need to be said to the International Tribunal on the Law of the Sea. Otherwise, we're going to be faced with more greenhouse gas pollution, more of the same, more excuses, more offers of money, as if this planet is up for sale. It's not.
And anybody in the room, please put up your hands. We'll get you the mic. I was very struck by your question, where the youth of the Caribbean, I think the first case I saw dealing with children litigating in favor of the environment was a 1993 case from the Philippines, the children's case, Opposa against Factoron, and I've been following the Montana case. I'm interested to know how you think we can help our young people and young lawyers perhaps get ready for that kind of litigation. Should we be intervening at the law school, or in what ways you think perhaps we could help to get ready?
Well, I would hesitate to say what should be done, but I think there are a range of options that people could choose from, and one is definitely the young lawyers at the law school. The other is, the Commonwealth Lawyers Association has climate justice committees, and it's doing work on climate justice, and so there is an opportunity for people to join, to make connections, and to learn through that network as well. But ultimately, it's going to come down to winning hearts, for people to feel that connection to what's around them, to nature, and to decide that they have the power to create a different future, because this generation and the previous generation, my generation, have really made an awful mess of things and burdened the next generation. I mean, we haven't even talked today about the need to remove the greenhouse gas pollution. We're talking about cutting emissions. No. We've reached the stage where scientists like James Hansen say we have to start taking out the pollution in the atmosphere for the sake of these young people. I want to see them understanding that so they have the power to decide what they're going to do.
Ms. Foster has another question. She says, bearing in mind that the CCJ's Guyana's final court of appeal, she's interested in your sense of the CCJ's sensitivity to these issues on climate change and environmental protection. And she is noting that Justice Winston Anderson is a former professor of international law at Cave Hill. International environmental law, I beg your pardon, at Cave Hill.
Yes, Justice Anderson has also written an excellent book on environmental law. I think the answer to the question is really going to depend on what sort of cases reach the Caribbean Court of Justice and what sort of arguments are put before the judges and what sort of evidence. And we just have to wait and see, I'm afraid, on that.
Okay, I think we have a couple of questions from the audience. Let me just get the mic to you, Dr. Barnett.
Thank you, and thank you for the presentation. With respect to children, I think one of the deficiencies is that we do not teach civics in schools, and if civics is taught in schools, then environmental matters could easily be included. I was very impressed by a recent presentation which was published in one of our newspapers, in which there were essay competitions in a particular school, and very excellent essays were written by the students on the environment. And I think this type of activity can stimulate interest among the younger generation.
Thank you very much for the presentation. Just a question. So not all climate change cases these days are pro-climate cases, meaning are there equally a growth of entities challenging climate policies and climate regulations, for example, to suggest that they are unfair, businesses or corporations? I just wondered to the extent that the reverse may be happening, and whether, as entities preparing for pro-climate litigation, we need to be aware of the arguments being put in the other direction. I hope I'm being clear.
Yes, is the short answer. There are moves to remove existing laws which are designed to protect the environment, and that is, to some extent, one of the reasons why, when I was talking, I was spending quite a bit of time, on the arguments being raised by the polluters, because we need to be able to deal with those arguments. If you talk to them about human rights, they're not interested. If you talk about environmental rights, they're not interested. And while those things are why we do what we do, I often say, don't confuse the goal with the methodology. We want to save the planet, but saying we want to save the planet doesn't carry much weight. What is the legal rule that will enable us to do that? So to come back to give you some examples, some investors recently have sued their pension fund because it wants to divest from fossil fuels, and they're saying, no, you have to stay here because that's how we get lots of money. And this is a very interesting case because you know, given that the fossil fuel industry is only being propped up by government subsidies and it's getting away with this because of market failure, correcting that is going to put them out of business. And that means already people are aware of that, and already quite a lot of this is stranded assets. How are you going to get your money out? Because if you are an investor and you sell your shares, you've got to do it in a way that doesn't drop the share price. So investors have a massive problem, and the only way they can really deal with this is to keep on pretending that fossil fuels have a future, because the market depends on confidence.
Okay, I see the hand. I'm going to come to you in just a moment. But here's a question online from Orville Gray. What's your take on the potential impact for litigation from fisher folk and other marine interests in archipelagic states, noting the challenge that still exists in stopping emissions? Are Caribbean states ready for a legislative perspective? And if not, what needs to be done to get ready?
I think that the answer is yes. I think there's huge potential for fisherfolk, for people to bring cases in relation to the sea. I didn't read out to you the question to the International Tribunal on the Law of the Sea, but that talks about pollution. States do have an obligation to protect the marine environment and to stop pollution, and that's a very interesting and useful approach. I don't know in Jamaica to what extent those obligations would be relevant in court, but to the extent that they affect human rights, they would definitely be relevant in a court in Guyana, because we have a provision of the Constitution that says when the court considers fundamental human rights, for example, the right to life, which is actually what we're talking about here, the court has to take into account jurisprudence, international jurisprudence, international treaties, and so on.
Okay, so talking from the NGO fraternity. So for example, we have noticed that a number of communities, for example in Jamaica, is being impacting. The minister mentioned before that last year we had a bad drought, and it has been affecting a lot of communities and stuff like that. Question to you, in bringing up the climate change litigation case, how do you empower NGOs, or how is it funded? Is it an expensive venture?
How do we?
The funding part about bringing up a case. How is it that you're funded?
How is it?
Funded. Sorry.
I think it varies from country to country. The very first case that we filed, Gaskin and the Minister of Natural Resources, there was no money. There was only one lawyer who was prepared to work on this with me, and I had to take the documents myself and line up in the registry with all the clerks to get them filed. You just start with what you've got, and you just keep going and see what happens. You know, think of it. You know, imagine that you're in a fog. You don't think, well, I need to walk a mile, and I better not, I can't go because I can't see a mile. You just think, right, I can see 5 feet in front of me. I'm going to walk forward that 5 feet. And then when you get there, you see, well, how far can I go? And then you get there and you see, how far can I go? Because if we wait until everything is right, you're giving the fossil fuel industry a free run to destroy the planet. They don't stop.
Thank you for that presentation, Melinda. I'm very happy to meet you. My name is Diana Macaulay. I'm a long-term environmental loudmouth activist, I guess. And my question to you is about time. I too have followed these many cases, and I've seen some of them come to a decision, but the courts are, it seems to me, are often used as delaying factors. And your presentation made very clear we don't have time, in fact. You know, this long known problem is already upon us. So to what extent do you think, given the fact that there's a time crunch and legal action takes time, not so much funding as courage, to what extent do you think legal action needs to be supported by the kinds of public campaigns that bring people to support them? Kind of referring back to your question about where's the youth of the Caribbean in this fight. Do we need public campaigns to support the litigation that's taking a while?
Yes, I think is the short answer. It's absolutely critical that it's not just left to lawyers and judges. What works in every country, obviously, is going to be different. But public opinion, public movement, public questioning, public demanding accountability from government, that's the foundation of democracy. That's what makes sure that governments have to behave in the first place. And only when they don't do we then go to litigation. But public pressure creates the environment which tells politicians how much leeway they have. So public pressure is really, really important. I'd like, if I may, just to talk a little bit, though, about your point on delay. Delay is fatal for the planet. And I think what we have to do is to ensure that governments put the resources into the judiciary and that the judiciary is given the training that it requires in order to deal with this. In cases now where people are still questioning the impacts of climate change, the judiciary may, have to rethink this, because if you've got school children protesting and bringing cases in court because they understand the impacts of greenhouse gas pollution, how can judges say, well, they don't understand, they need expert evidence and so on? This is a very interesting issue for the judiciary.
Question from Donovan Walker online. Do you have any views on the 2022 U.S. Supreme Court case of West, I think, Virginia against EPA? That case recognizes a new major questions doctrine, which seems to have the potential to upend the discretion that U.S. courts have historically granted to agency decision-making. And if so, how do you think this might impact environmental issues?
I'm going to have to email you an answer to your question, because it's a very good question, and I haven't read the judgment, and I'm not going to pretend that I know what the answer is.
All right. Any more questions in the room or online at this point? Okay. All right. Well, we're going to take the break now, coffee break. And then we are going to move into the panel discussion with another set of fantastic speakers. And Ms. Janke, of course, remains with us and will continue to answer questions a little bit later. So get up, folks, stretch, walk around a little bit, and get ready for another fantastic session. We will be coming back at 10 minutes past 11. I'm just going to, I'm not even going to use the word introduce because I know my three speakers are well known to everybody, but I'll just remind you briefly of some of their main achievements. We have with us, we're so honored to have with us Professor Michael Taylor, who is Professor of Climate Science and Dean of the Faculty of Science and Technology at the Mona campus at the University of the West Indies. He's co-director of the Climate Studies Group at Mona, and he's also consulting lead author on the special report on 1.5 degrees from the Intergovernmental Panel on Climate Change. So when I tell you we have globally recognized brilliant minds here in the Caribbean and in the room, you know what I'm talking about. And Prof is going to be giving us a scientific overview of the issue, but one of the fantastic things about Prof is that he talks so everybody can understand him. Fantastic person to interview. We're also going to be hearing from Daniel Andrade Goff, who is going to be giving us a look at what's happening with the national legislation. Daniel is a Jamaican attorney. She's a partner in the law firm Goff Law. She has a great deal of experience in environmental law, and she served for 7 years as an elected representative for the Escazú Agreement, which we're talking about earlier. That's the regional agreement on access to information, public participation, and access to justice in environmental matters. She's a previous legal director of JET, and she now sits on the board. And as well, we also have with us Dr. Lloyd Barnett. And, you know, there's a phrase we use when we say people write the book on different things. Dr. Barnett literally wrote the book on Jamaica's constitutional law and also has another very important book on constitutional law recently re-released. And Dr. Barnett's name figures in almost every constitutional case of importance that has come out of Jamaica. Hines, which we all learned as law students, and which law students all across the Commonwealth are taught, and which every lawyer in every constitutional case starts with Hines. Also, he's been in, of course, Syringa Marshall Burnett, the so-called CCJ case, and as well what we call the Senate letters case, Holness against Williams. So I'm going to start by asking Professor Taylor to give us his overview.
All right, I want to thank Jed for the invitation to speak. Really appreciate it. I must tell you, I was troubled. I wondered what I'm doing in a room. I'm a scientist, and this is a room of legal experts. But I want to thank Ms. Janke, because I think she laid the groundwork well for me, that at the essence of this, you're going to need science and evidence to form the basis of this litigation. And so science very much has to be in the room. But then it also posed another problem for me, because I always talk about, you know, well, what does climate science say about climate change and Jamaica? And having been given only 10 minutes, there's no way, because once I begin to quote the science to you and quote all the things in relation to the science and Jamaica, the 10 minutes will be finished, and I know our moderator will not permit me to go over the 10 minutes. So, having said all of that, I want to take a different approach. What I want to do is give you what I tell you the 4 types of science questions that at climate science, well, 4 types of questions that climate science have been attempting to answer in its evolution. So, 4 kinds of questions that climate science has been attempting to answer in the evolution of this whole climate change problem. Why? Because if I can give you those 4 types of questions, then you now have an idea of what kind of data exists out there. And I don't need to go through the entire set of data, but it is there simply for your looking up. So, and once you know what type of data is available, then you know how science can support the litigation process. So let me tell you quickly these 4 types of questions, and I will be very quick. The first type of question that the climate science has been attempting to answer are what I call questions about manifestation. So these are the kinds of questions that say, well, what can climate science tell us about how climate is changing, both in the past and going into the future? So that is almost the starting point. When climate change began to become an issue, this is where the questions started. Manifestation questions. How is climate change manifesting itself up to now and in the future? Well, I'm not going to try to answer it all, but certainly what has emerged is because of the long-term attempt to answer this, we now have data showing us, yes, there are discernible changes in our climate. And that data exists, first of all, at the global level. So you only need to see that the graph is going up. And so you know this data. We have warmed by about 1.1 degrees since pre-industrial times globally. You know, that's the level of warming that we have warmed. But we also know it for the Caribbean, and I don't have the time to go through it, but you know, therefore, that if you look on the State of Jamaica Climate, Volume 3 report, which is out on the PIOJ website, you know that the data exists to show that we're hotter. We're having 23 more hot days in a year than in 1950. Where is that going? That was yesterday when it was so hot. So summer is starting earlier and lasting longer. You know our rain is way more variable. You know we're seeing more extremes. Those are the droughts. The minister quoted one. And you know we're seeing higher sea levels. That's the lack of a healthier beach. So we know that the science has done a good job of showing that there are discernible changes in our climate. And it's not only for the present, but it's also for the future. So this is the graph that shows no matter the scenario or the storyline we take about how the world will develop, the temperatures which we have seen, which is a black line, just keep going up. Depending on if it's a best case scenario, you may see 2 degrees. Depending on it's the worst case scenario, that's the top red line, you may see 3 to 4 degrees globally. So we know that these discernible changes are going to continue. And we know that's true for the Caribbean, because that's the work that we do at the University of the West Indies. So we know that to come in the Caribbean, we're going to see at least 2 to 4 degrees hotter. We have seen one already. We're going to be variable. Our rain is going to be variable, but vary about a lower mean. So we're going to be 40% drier. We're going to see more extremes, more extreme hurricanes, intense hurricanes, and more intense droughts. And we're going to see sea level rise, at least going up to 1 meter of sea level rise, whereas we have only seen 3.5 millimeters per year so far. What am I saying? The first type of science question that has been asked are questions about manifestation. Because we have asked those questions for a long time, data exists that says there's a discernible change already in the climate for our country now and in the future, and you can find that data. Very quickly, the second type of question have been questions around causation. And so these are the kind of questions that says, what can climate science tell us about what causes climate change? And boy, we have heard enough. We have heard a good treatise on that. Because we have asked those types of questions next, what we have is data about identifiable causes of climate change. So on the global level, we know that the causes are human activities. And you know, when you get the presentation, the 1.1, you can split out what is causing that 1.1 change. So there is human activity, the greenhouse gases, and there are even positive human activities that offset it. So in fact, the 1.1 is after you add in the offset of what the human activities are doing. So it's very clear, the science tells us greenhouse gases are those causes. And those greenhouse gases are clearly due to our human activity, land use, energy, lifestyle, consumption patterns, etc. It even goes further to push that. Who are the biggest emitters? And I think I don't need to tell you. You know, globally, the major share of greenhouse gases are not evenly distributed, and SIDS, like us, only produce about 0.5% of the greenhouse gases. So the second type of questions are the causation questions, and data exists that identify the causes. Quickly, there's a third type of question, Having asked, you know, the questions about manifestation, data is there. Having asked the questions about causation, we know the causes, the data is there. The third type of question is clearly about implications. And those are the questions that say, well, if you can tell me what's happening and you can tell me the causes, can you tell me the consequences of climate change? And again, because we have asked those questions for a long time, I'm not sure what happened there. My presentation is going blue. Just continue. Okay. All right, because you've asked, there's data about those recognizable consequences. What do I mean? Well, on the global stage, you already know climate change has caused widespread adverse impacts on food and water security, human health, economies and societies, loss and damage to nature and people, and vulnerable people who have not caused it are disproportionately affected. It also means, because of the work we are doing in the Caribbean, that data exists for the Caribbean. What do we have data for? Showing that terrestrial freshwater and ocean ecosystems are adversely impacted, that human systems, so think about water, food security, health and well-being, settlements, infrastructure are impacted, and that climate change is exacerbating existing vulnerabilities. The data exists, and we can break this out. So that's a third type of question. For me, the last type of question, which has always been the bugbear, and in fact, I think you heard the minister in a roundabout way address it, are the questions about attribution. The truth is, for a long time, if you asked, well, let's take that cold front that came in January and damaged Negril. Was that due to climate change? And as a climate scientist, I would have had to have said, well, we can't take one event and make it into climate change, though we know climate change is clearly playing a role. And so there are the questions that say, what can you tell us, climate science tell us about climate change's contribution to the storm or the damage it's causing? Why for me this is an important question is that in the last 15 years, there is emerging what we call attribution science. And attribution science is finally giving us the data for quantifiable contributions. And this is important. So what is attribution science? It's very new science. It uses weather observations and models, things that we work with, to understand how climate influences the intensity and likelihood of an extreme weather event. At last, we can put numbers to what's the climate's impact on an extreme event. Very careful to point out that climate change, it does not tell you if it caused the event, but it tells you what the contribution of climate change was to the intensity. That's a game changer. Why is it a game changer? I'm using the words of Salim al-Hook. Well, you don't need to worry. It adds new weight to legal cases. It is the game changer that we have wanted in science. So if you begin to just do a moment, it will be this. Well, we have always known the percentage greenhouse gas and its contribution to climate change. I told you about that with the causation. We've always known the damage from events. We've told you that have been the implications. Well, suddenly, if I now know the percentage that climate change contributed to that event, and if I know what the polluters' contribution to greenhouse gas emissions were, I have a quantifiable way to measure the polluters' contribution to the damage. Attribution science is the linchpin. Now, the truth is, and I'm finishing, attribution science is so new. There are less than 1,000 cases, published cases of attribution science. There are two that I know for the Caribbean region. One is for that 2013 to 2016 drought. I don't know if you remember, we had a 3-year pan-Caribbean drought, which was severe. We felt it horribly in the Caribbean. And the study gives us some numbers at last. It says anthropogenic warming increases severity of the event by 17%. We now have a number, which is climate change, and the spatial extent by 7%. And what attribution science is saying, I can now take any individual event, once I have the data, and we can talk about how attribution science works, and come up with the number of what climate change is doing to that event. It is even going further, because in any event, let's take a flood, we know it's not just climate change causing the problem. There are also bad policies, people living in the wrong places, etc. But it is going further to sift that out and then say the contribution. Once I can say what climate change has contributed to an event, I'm providing data to underpin the litigation process. Brand new science. So what's the last thing I will say then? The Caribbean has a vested interest in developing an attribution science program. This is me putting on the research hat. Why? Loss and damage is going to depend on attribution. There is no easy getting money out of loss and damage unless you can say you can attribute to climate. The whole climate justice movement is going to depend on attribution. We have a vested interest. Do we have the capacity? Absolutely. We have been doing modeling for 20 years now, and we know the modelers across the region. However, it will take a systematic, coordinated, collaborated approach. But if we really want the justice, that's where the new science has to come in. So that's it. That's my presentation. 4 questions that have been asked. The manifestation, we have the data for the discernible changes. Causation, we have the data for the identifiable causes. Implications, we have the data that shows the recognizable consequences. And now the game changer, attribution, and we're beginning to get the data for the quantifiable contributions of climate change. Thank you very much.
Thank you. Good afternoon, everyone. So, following along with Professor Taylor's footsteps, I'm going to aim to stay within my 10-minute mark. Madam Moderator. Okay, so I will be talking a little bit about the national legal framework. So what exists in Jamaica when we're thinking of positioning ourselves for climate change litigation. Now you heard the previous speakers speak to the fact that climate change has disproportionate environmental, social, and economic impacts on certain groups. These are typically the marginalized and vulnerable groups. Now, there was a report that was done by the Economic Commission for Latin America and the Caribbean a few years ago. And in that report, it indicated that 90% of the world's disaster victims are in the developing world. And they suffer and are at risk from disasters such as floods and droughts. Now, in Jamaica, we know who these people are. There are farmers or farming communities. There are the fishing communities. These are the persons who experience the droughts, experience the floods, experience the disappearing beaches, much more harsher than the average Jamaican person. And I say equity and justice and fairness demand that we need to take into account the rights of these vulnerable groups in the context of addressing the climate change crisis. And if we do so, their rights need to be safeguarded. Now, much of the litigation at the local level, right, and in Guyanese and in other Caribbean countries and across the world has looked at the planning and environmental framework, has looked at the legislation that exists at the national level, because at the end of the day, these are the laws and policies that are in place to protect the environment, and in doing so, protect persons' lives and their livelihoods. And that's why I'll be touching on a bit about the environmental and planning framework in Jamaica. One of the things that I wanted to highlight about vulnerable groups that I think is something we also need to take into account in terms of climate change litigation in Jamaica is that these groups are often the ones that have the least adaptive capacity. So not only are they disproportionately affected by climate change impacts, but their ability to adapt to it, whether it's to move or to relocate or to enter into a different enterprise or industry, is typically affected by lack of resources, lack of income. And that makes the situation even more critical for us to understand. So what I want to do is to just put myself into the shoes of the vulnerable person. And what can we do? So I'm not going to spend a lot of time on the planning legislation and environmental legislation because I only have 10 minutes. And I'm going to assume many lawyers already appreciate that we do have planning legislation in place, the Town and Country Planning Act, the Building Act, among others, to ensure the orderly planning of the country in order to ensure environmental protection. And in terms of environmental legislation, we do have the Natural Resources Conservation Authority Act, which establishes the Natural Resources Conservation Authority. And one of the key things about that legislation is that it allows this statutory body, the NRCA, to require for certain applications for development, if they think there's a significant likely impact on the environment, they require the developer or the applicant to produce an environmental impact assessment. And it is through that process of doing this study, this EIA, that developer or applicant is required to explain what are the likely impacts of that particular activity on the location, on the surrounding communities. And I dare say climate change features when we talk about the likely impacts there. Now, because we're talking about vulnerable people and their rights, I wanted to start out by saying, first of all, we need to look at a rights-based approach to climate justice. And first of all, when we talk about rights, we have to talk about access to environmental information. This is a right to obtain information, for example, about the scope and the impacts of a likely action or decision. Public participation in environmental decision making. So the right to be consulted before a decision is taken. And access to justice, which is that if there's a violation of these rights or the right to a healthy environment, there should be an avenue for redress. I know you can't see the screen, the words, I know it's small, so I'm just gonna explain that. At the international level, these rights are well known, these procedural rights. So we have dating back as far back as 1992, the Rio Declaration, which in Principle 10 of that declaration expresses that environmental issues are best handled with the participation and involvement of all citizens. We have the Paris Agreement that makes a connection between these rights and climate change by saying that in order for countries to really tackle climate change, we need to ensure that persons have environmental information, that they participate in decisions around climate change and climate action. And so you can see where I'm going with this when we're talking about what climate litigation is and a rights-based approach. Are our citizens, are the vulnerable groups, are they involved in the decisions that are taken on a daily basis that may affect either the impacts on climate change or their capacity to adapt to climate change. And last but not least, the Escazú Agreement. Much has been said on this. I won't spend a lot of time, but just to say that this is probably the newest agreement that seeks to endorse and enshrine these rights of information, of participation, and justice. And it's quite extensive in terms of setting standards for these rights. There, we have a right to a healthy environment due to a constitutional amendment. And I'm not going to speak too much on that because I know Dr. Barnett will be speaking about the Constitution. And then we have a right to access information. So under the Access to Information Act that was passed in 2002, every person has a right to request from public authorities any official document subject to limited exceptions. And that actually has been used in many cases by JET and others to obtain environmental information around what the government is doing, what are proposals that could affect communities, what are plans that even affect our ability to adapt to climate change. Just to mention, because I wanted to lay the foundation for the development planning process. So when we talk about access to environmental information, I don't know how many people are aware, but the legislation also speaks to the fact that local authorities must keep these registers of planning information that must be publicly accessible. Now, I wanted to speak about a case in St. Kitts and Nevis. So when we talk about access to environmental information and these registers, I have unsuccessfully been able to obtain information in Jamaica. In St. Kitts, somebody tried to obtain information from their local planning authority relating to an application for a development. And what the court held in that case is that not only were the local authorities just able to decide what information is on their bare application, but taking a purposive approach, they were on their duty to ensure that the information that was provided in those local registers allowed the public to get a true sense of the scope and the impacts of the proposed development. When we talk about public participation, the right to be consulted in the decision-making process, so we have, as I mentioned before, environmental impact assessments that are usually requested or required whenever the NRCA decides that a development is likely to have a significant impact. Now, it's at the discretion of the NRCA to decide whether or not a development may have a significant impact. And it's also something that where the extent and the scope of public consultation is also at the discretion of the NRCA. However, there have been cases that have shown that even though we don't have there's a lack of a mandatory duty to require public consultation in certain circumstances, once that consultation is voluntarily undertaken, then the local authority is held to a certain standard to ensure that that consultation is meaningful. So it means ensuring, for example, that persons are adequately informed and that the output of the consultation can be taken into account in decision-making process. And that's commonly referred to as the gunning principles. It's something that's been cited throughout cases in Jamaica, in Belize, in Trinidad, and in other countries. So we say the common law supplementing the gap where we don't have it in legislation. This is an example of a case in Jamaica where the Jamaica Environment Trust and some of the applicants took the NRCA and the National Environment and Planning Agency to court around a decision to approve a development which ultimately led to the relocation of a fishing community. And in that case, one of the things highlighted was the fact that There was no requirement, a legal duty to have consultation, but nonetheless, one was voluntarily undertaken, and the gunning principles were applied in that case to hold the government to account to ensure that the standard for consultation was met. There's another case that Jamaica Environment Trust was involved in. This had to do with the Palisades Strip. So many of you would recall, we didn't always have boulders on the Palisades Strip, and this was a project that was implemented some time ago. Initially, the project was much smaller in scope, and then there was public consultation held around that. The project was amended, and later that amended scope of project was not put to public consultation. And that was challenged before the courts, and the courts held that where you have changed or revised the scope of works, you have to reconsult the people. Now I want to talk about access to justice barriers. So one of the main issues I think we face when we're talking about vulnerable groups and the impacts of climate change and developments that affect their adaptive capacity is the fact that the access to technical and legal assistance. We don't have a strong and vibrant, in my opinion, public interest movement, especially when it relates to environmental cases. The technical nature of environmental claims is another issue. So the difficulty in obtaining evidence of the likelihood of harm. The potential harm to environmental defenders. So there are some lawyers I know who have taken a step back from public interest work because there's a fear that the culture in Jamaica, the violent culture, it may spill off into their personal life. And then the lack of third-party rights under our planning legislation. So when a decision is made to approve or to grant planning permission, it's typically, as the legislation spells out, it is the applicant who has rights to appeal under the planning legislation. And the reason why I raise this as an issue is because if we go back to the concern about access to the courts, access to judicial review, access to constitutional claims and a lawyer, really and truly, maybe we should be thinking that we should allow for a space where persons do not need that level of legal representation, where it can, at the administrative level, persons are able to challenge certain decisions, planning permissions. So I have here a dissenting judgment from Justice Bertram Linton in the Ashton Pitt and Attorney General case, which probably many of you are familiar with. But this was a gentleman who challenged a petroleum storage facility, the planning permission for that. And he said that the Town and Country Planning Act, one of the things he said was that that act was unconstitutional because he didn't have a right to appeal under that act. The majority of the court said, well, you can do judicial review, you can bring a constitutional claim, you have equality before the law. And Justice Bertram Linton, in her dissenting opinion, felt that it was unconstitutional, that if we are talking about equality, it means ensuring that everyone had a voice to be heard. So this is my final slide, and I know I'm out of time, so I just wanted to talk a little bit about a recent case, fairly recent case, regarding a challenge to permission for a mining operation. It was a constitutional case, and in that case, I thought reading it that there are some things that I think we could, or lessons learned, or things that we should be aware of if we're talking about climate change strategy. So one of the issues in that case, they were seeking an interim injunction, was weighing the balance of inconvenience. So development, or which is this mining operation that stands to lose millions of US dollars, versus weighing the balance of inconvenience in the people who are claiming damage and harm to their property as well as to their health. And the court in that case took a view that in balancing the inconvenience, the information on health impacts was speculative, it was based on assertions, and so one of the things that they really, really brought home for me, at least in that case, is that the courts want the science, they want the evidence. So we have to make that connection with climate change impacts if we're talking about climate change litigation. And final thoughts. So we have increased recognition of these rights at the international level. We have case law looking at violation of these rights and inadequacies. And then to ensure climate justice, we need to ensure that our legal framework addresses particular challenges, such as these barriers facing vulnerable groups in accessing justice. Thank you.
I'm very happy to be with you all. I start my paper on the topic of public awareness, which in fact is the corollary of Professor's starting point of manifestation. And it reminded me of my personal experience when some decades ago I was on a cruise in the Arctic region, and I was on the deck of the ship admiring a beautiful structure, almost of silver. And this cathedral-like structure that I was admiring suddenly started to fall. And I became very depressed because this was falling into the sea. And when I asked what was happening, I thought the world was coming to an end. They said it's the warm climate that is causing the ice to melt. And so these things are falling into the sea. We are not going to solve the climate problem without public awareness of the extent and seriousness of the problem. I was very impressed when recently in a competition at a St. Mary Technical High School, children wrote very impressive essays in which they stressed the impact of climate change on one of Jamaica's great assets, its beautiful landscapes and captivating scenery. But public awareness is increasing, and to create an atmosphere in which litigation can be effective and successful requires that that awareness be intensified and expanded. The young essays did not mention litigation as a solution, but mentioned public intervention. The official governmental approach has concentrated on technological needs assessment, adaptation, planning, climate finance, and regional and international partnerships and cooperation. However, it is recognized that civil society advocates must fill the gap, and that the legal framework for climate preservation requires greater legal activism. In the legal framework, the beginning is international law, because climate is an international subject. International law establishes a basis for cooperation among states. It is recognized as deserving the respect of citizens in liberal constitutional democracies. However, the prescription in favor of compliance with international law can be overridden by national policy, lack of legal jurisdiction, restrictive domestic procedures, and internal expediency. Jamaica is a party to a host of international conventions dealing with climate change. But these conventions are aimed at fostering voluntary cooperation rather than to confer enforceable legal rights on states in international law. Still less do they purport to grant enforceable legal rights to individuals. In any event, as a general principle, in Jamaican law, such international obligations are not enforceable in litigation in the domestic jurisdiction. Nevertheless, although these international conventions are not directly enforceable in domestic law, where local legislation is aimed at implementing the conventions, the courts will take them into consideration. And I've quoted cases from different jurisdictions which illustrate how that comes about and is implemented. Now, there's a range of domestic legislation which provides some potential for litigation in the field of climate control. There are acts dealing with clean air. There are acts dealing with natural resources conservation. There are acts dealing with pesticides. There are things dealing with town and country planning, water resources, and wildlife protection. In effect, the entire range of the components of the environment comes directly or indirectly under some measure of statutory control. However, there have been many cases of pollution of rivers and streams, sewage waste, escapes, destruction of mangroves and the natural features of the country, harmful fumes from dumps, which have neither resulted in effective action by the authorities or legal claims by affected individuals. Litigation based on the statutory provisions is therefore essentially limited to cases in which the government's authorities prosecute the non-compliant or the individuals whose actions cause personal harm to a citizen. Nevertheless, there is significant potential for litigation where a public authority grants a license or permit to carry out schemes which are inconsistent with the objectives of these statutory provisions, or where those authorities fail to comply with their statutory obligations to prevent or control harmful activities. And this area of litigation falls in our traditional administrative law and judicial review proceedings. One important handicap to litigation as a means of combating climate change is that legislation, while it seeks to regulate a wide range of activities having the potential to damage the environment, tends to be general and vague. And this makes it difficult for the courts to enforce compliance with the required standards. Mention was made of the Northern Jamaican Conservation Association case, where the civil society organization challenged the decision of the statutory authority to grant a permit to an investor to build an hotel at Pear Tree Bottom, an area which was rich in biodiversity and ecological value. And Mr. Justice Sachs, as he then was, upheld the application for judicial review. And this decision illustrates the potential for litigation to ensure that proper environmental impact assessments are carried out and a fair opportunity given to members of the public to object to measures which threaten the environment. And then there was a more recent case of Jamaica Environmental Trust versus the National Resources Conservation Authority, where Ms. Justice Straw held that the regulatory authority had failed in its statutory duty to disclose the revised plan on which the project was being implemented. Her leadership granted a declaration that the statutory authorities had reached the legal standard for consultation and the legitimate expectation that all environmental information relating to the subject development would be disclosed to the public. However, and this takes into account what our experts have said, the prospects for the effective tackling of the problem by litigation is less where the main cause of climate change, namely global warming, is taken into account. The causes of global warming, namely greenhouse gas emissions, the burning of fossil fuels, and deforestation are largely the result of governmental policy and national programs on an international scale. These results from the burning of gasoline and coal, emissions from factories, ships, aircraft, and motor vehicles, the generation of electricity from oil, all of which are legally authorized or sanctioned and even encouraged by the authorities. There is therefore limited scope in Jamaican law for employing litigation to control these factors or control the institutions which engage in these activities. One important development is the liberalization of what in law is called standing. The modern approach in judicial review proceedings is to permit a person with a sufficient interest to bring actions. And because environmental matters are so all-embracing, it becomes much easier for a person to justify the taking of the initiative to institute litigation. In a recent case, in fact, the Privy Council decided this only a week ago, the appellants had instituted judicial review proceedings against the respondent. The case concerned the construction of an airstrip on the island of Barbuda. The appellant questioned the impact of the airstrip on the environment, on the Bermudan fallow deer habitat, the red-footed tortoise and other wildlife and bird life. And the Privy Council held that he had demonstrated sufficient interest in the environmental issues so as to justify his bringing the action. It seems, therefore, that the problem of proving or establishing the right to challenge action which threatens the environment is now much easier than previously. In Jamaica, the most important development is that provided by the Charter. The Charter binds not only governments, but it also binds individuals and corporations, so that it has both a vertical as well as an horizontal impact. With respect to the environment, the Charter grants a right to all persons in Jamaica to enjoy a healthy and productive environment free from the threat of injury or damage from environmental abuse and degradation of the ecological heritage. This is a comprehensive protection of the environment and the grant of the right of the citizen to take action to preserve the environment. And there is emerging jurisprudence, therefore, which tends to favor a progressive and liberal application of these constitutional provisions. And there is a citation in the paper of Indian and Australian cases which deal with this problem. The moderate optimism which we can therefore express on the local level is, I suggest, quite reasonable. What is more challenging and intractable are the global abuse of our planet by deforestation and the continued expansion of oil exploration, drilling and burning, which is driven by strong economic interest and ambition, and the previous speakers have spoken of that. Thus, Guyana has embarked on the extraction, and Jamaica is engaged in exploration. To what end? Accordingly, I conclude by saying there appears to be very little further scope for constitutional changes which will facilitate litigation on these wider environmental challenges relating to global warming and climate change. But what we do have is the opportunity to use the existing provisions to deal with those abuses which are current and immediately available and obvious to us. For instance, there has been, over the years, the continuous permission of sewage water to be released, not only in our coastal waters, but even in our streets. It is not, I think, in the interest of Jamaica or patriotic for us to allow that to continue to happen. And the only way to stop it appears to be by litigation.
Thank you so very much, Dr. Barnett, along with Professor Taylor and Mrs. Andrade Goff. So we are going to take some questions now, running a little bit late, not very late, but we do want to engage some of your questions. So let me start with a question I have coming in from online. And I'm just going to throw the questions to the panel. Anyone can take it. And Leslie Walling is asking, will each Caribbean country, and perhaps I could invite Ms. Janke to join us up here. Thank you. Will each Caribbean country have to separately take legal action to ensure that Exxon indemnifies potential national losses and damage from a massive spill? That sounds like you, Ms. Janke.
What's the question?
Will each Caribbean country have to separately take legal action to ensure that Exxon indemnifies potential national losses and damage from a massive spill?
So I think that's a really interesting question, because the first thing you have to ask is what is the legal rule? What's the basis of the claim? In Guyana, obviously, we have those rules in place, and that's the basis of the claim. Excuse me. You might want to think about this in a slightly different way, because what about the precautionary principle? What about the avoidance principle? What about the requirements of due diligence under international law? And so perhaps you might want to think, well, what actually are Guyana's duties towards sovereign states in the Caribbean, and take it from there? Because at the end of the day, it's the Guyana government that is giving the permits and the licenses to allow the offshore drilling to take place and the transportation of the petroleum products possibly through the waters. I'm not entirely sure whether it goes through the Caribbean, but that might be a better place to start than looking for a guarantee, because you can't clean up an oil spill. The oil just disappears because it's in the ocean. It goes down. Do you really want it going down in the ocean?
Thank you so much. And please put up your hand if you have a question. In the meantime, Prof, let me ask you, and I loved how you tied the science into the litigation. Now, this is not a legal question. I'm just asking if you've started to see any kind of indication that the attribution science is actually starting to make a difference in whether the initiation or the success of climate litigation.
It might be a little too early. Attribution science is really new science. I would say the first attribution science case came out in about 2003, 2005. But you're beginning to see, well, not in the Caribbean region, you're beginning to read about people who are taking the attribution and beginning to make cases. Not my area at all. There are limitations to attribution science, however. And as I've said, in the Caribbean, I only know of 2 studies. I gave you one, which was the drought. The second one was Dorian. Everybody remembers Dorian was, people think greater than a category 5, lingered for a very long time, and they have shown the contribution of climate change to that. My suspicion is that the better we get at doing it, the more we build our own capacity to do attribution science. And I cannot emphasize that enough, because right now attribution science is done in the developed world. So the very people who are the cause are the holders of the key to do so. the more, then I suspect the more we will see attribution sides playing out in the legal world.
All right, so let me just say as well that, okay, we have a hand there. We will get a mic to you. So while we're getting the mic to you, Daniel, let me put a question to you. In the meantime, listening to your overview of the legislative framework, do we then need additional legislation, you think, to fill in the gaps? You spoke about the lack of third-party rights in planning legislation, as well as things like, lost my track, but basically, that's my question. Do we need additional legislation?
Thank you. I would argue that yes, we do. I think there are some clear gaps. I highlighted a few of them, which is the right to be consulted. So in our legislative framework, there's no legal mandatory duty to consult for environmental permits. And I would argue that we should have that. There are many other countries that do, including in the Caribbean, who have this requirement. So if there is let's say, for example, an application before our planning authorities from, I don't know, it may be ExxonMobil or someone else, to do exploration, offshore drilling in Jamaica's waters, wouldn't you want a clear legal mandate to consult the public? I would argue yes.
Okay, good afternoon, just afternoon. First of all, thanks to the panel. My name is Camille Facey. I chair the Corporate Governance Committee of the Private Sector Organization of Jamaica. I'm also a director on the board of the Jamaica Chamber of Commerce. Governance has become a big thing for private sector entities. ESG is a major component. And very often when I speak, I start by quoting Prof. Taylor, who says that at 1.5 degrees of warming, the Caribbean has half a chance of a livable future. Businesses then, through their directors, have a fiduciary responsibility to protect their businesses. It's built into risk management and a number of other governance components. IFRS, they are coming out with sustainability standards. So my question against that background is to government. What risk assessment has been done for Jamaica to say these are the risks that we face, and in light of those risks, these are the mitigation efforts that have been put in place? So for example, the seawalls like they have in Holland, or now that we've had that very excellent but frightening presentation from Prof. Janke, what actions can we take to protect ourselves against this kind of oil spill? Because the reality is that businesses are aware that they need to take steps to protect the sustainability of their businesses into the future. But businesses are also very aware that they should aim for net zero, and they're looking for guidance as to what do we need to do to contribute to the solution.
I just want to say something. I didn't mention it in my presentation, but I don't know how many of you are aware that Jamaica does have a climate change policy. And in that policy, it outlines specific commitments that the government will make and undertake, not only in terms of mitigation, but also adaptation. Now, I think Melinda touched on it, but there are also climate change litigation cases where citizens have actually sued the government to hold them accountable to some of their statements in policies and their commitments to adapt and to mitigate. So that, I think, is one area that we can also be thinking of. I'd invite everybody to look and see what the government has committed to do. And there are other documents there, NDCs, the Third National Communication. There's a range of climate change documents exactly that the government has laid out specifically for each sector and group what they are committing to do to deal with the climate change crisis.
Thank you so much, Daniel. Any other questions? We have just about 5 minutes before I say that Dr. Barnett's presentation was longer and more in-depth than the abbreviated version he shared with us. I hope it's going to be shared because I think you'll find it very, very interesting and very useful. But Dr. Barnett, you spoke there of the courts taking a flexible approach to standing, which we know has been a major hindrance in public interest litigation. Have you started to see the Jamaican courts being flexible and taking that flexible approach?
The Jamaican decisions have been positive and progressive, and therefore I think standing is not a serious handicap in Jamaica, based on the Constitution and because the Constitution provides that a civil society organization may bring actions under the Charter. So that not only because of the more liberal construction of the provisions relating to standing, both in relation to the Constitution itself and statutory provisions, I think that is not a big problem anymore.
All right, thank you so much. As well, all right, just before I ask the panel to just give a couple of final words, then I did want to ask as well, though, in terms of the going forward, and Daniel, I'm going to ask you, because, for instance, the whole issue of gap plugging in the legislation, do we need a process? I mean, who would be leading that process, you think? I know it's a hard question, but I know you can't answer it. Who would be leading that process to lobby for improvement in the laws and all the gap-filling work, because that sounds like a whole project in itself.
Thank you. So there have been assessments in the past. Dion, you might be aware of one such one that you are a part of, and focusing on the rights of information, participation, and justice, and where the gaps are legally that we need to plug. I just want to also mention that the government has embarked on developing a national action plan out of the Open Government Partnership Initiative. And in that plan, they have committed within the next 2 years to reform the Access to Information Act, as well as to develop environmental impact assessment regulations. These are things that we can look forward to. I think it's up to us as citizens to hold the government accountable to ensure that in these commitments, they actually do work hard to achieve them, and that we don't forget and, ensure that we follow it up. And the Ministry of Finance is leading that process.
And the cases have indicated a tendency of the court to require public consultation, and therefore, I think unless it is clearly excluded, there's a good case for saying that you can't grant a permit or a license to do something, which is if you do not give the community an opportunity to intervene and to make representations.
I just want to ask a very naive question. I'm not a scientist, but we're going through the process right now of constitutional reform. Is there a place in it for this to reflect itself in the Constitution? Is there a gap in the Constitution, and is there a place to enshrine something that will make this possible, the litigation sphere possible going forward? And I just ask that, is this an opportunity?
Well, Dr. Barnett is on the committee, so I'll let him answer.
The opportunity exists to make submissions, and I think this is an area in which civil society should definitely consider what to propose and how, because you have the background already in principle and in the Constitution own provisions in relation to the environment, so that if those provisions are going to be effective. I think you have an argument that you should be supplemented with the requirement for compulsory consultation.
Thank you so much, Dr. Barnett. Let me just give you a very quick recap of some of, I think, the main points and takeaways, and then I'll ask each panelist just to give us one very quick final comment in terms of the way forward, followed by closing remarks from Teresa. So Ms. Janke pointed out, I think one of the fantastic things listening to her is a realization that we do have climate litigation taking place here in the region that we can look to. We have processes and starting to see the precedents we'll be seeing that we can start to look to, and that she opened our eyes, I think, to the range of litigation efforts taking place elsewhere. And some of the questions she asked and some of the statements she made, I think, should stick with us. Where are the youth of the Caribbean in this process is something that's going to stay with me. Her exhortation that we need to talk truth to power, stop the lies, and that stopping pollution is going to mean putting the oil companies out of business. Prof. Taylor pointed us to 4 types of questions that he says climate science has been asking and trying to answer, and that will help us understand the process. Questions about manifestation, exactly how is climate change manifesting? Questions about causation, a word familiar to us in the legal community. Questions about the implications of the changes, and importantly, the questions about attribution, which he says this attribution science is going to be a game changer for climate litigation because it adds new weight to the climate litigation cases. Daniel Andrade Goff, who spoke of equity. Equity demands that we take into account and safeguard the interests of vulnerable groups, those same groups disproportionately affected and have the least adaptive capacity. And she identified some significant gaps in the national legislative framework. And I think the question is going to be, who is to help to plug those gaps, and how do we use climate litigation to preserve the interests and protect those vulnerable groups? And Dr. Barnett, who pointed out that climate preservation calls for greater legal activism, and he pointed to significant potential for citizens to seek declarations or judicial review. I think there as well a very clear call to action, especially with his assertion that the modern liberalization of standing really has removed a lot of the barriers that previously were in the way of this kind of public interest litigation. Let me just ask everybody for just one quick final 1-minute comment in terms of the way forward. Ms. Janke.
Well, first of all, thank you very much. And my comment, the solution is in this room. We have business, the environment, law, education, science, media. You know what you have to do. The only thing left to do is figure out how.
Thank you. So I'll just use the opportunity to let everybody know that, and Teresa had mentioned this before, but this is the first in a series of climate litigation seminars. And I think the first step that we need to do as lawyers is to educate ourselves and inform ourselves, because I recognize that this is an area that is very new for many of us. So I'd invite you as much as possible to participate in those ongoing seminars. If you want to get in touch with me or Teresa or anyone else, feel free to do so. But I think the first step is educating ourselves as lawyers, so this area doesn't seem so foreign. And maybe when we understand it and appreciate it more, when people who are in need or when issues come before us, we are more women and play our part.
My feeling from all the discussions we have had is that the problem is not law, but economics. The cause of global warming and climate change is fossil fuel burning. If we continue to drive motor cars that use that type of fuel, and fly in airplanes which use that type of fuel and travel on ships which use that sort of fuel or build factories which use that sort of fuel, then there is no permanent solution to the problem. And therefore, what we need to do is to advocate that obligations be placed on the government and the international industrial bodies to change their approach and solve the problem at the foundation.
I was going to say collaboration, but Ms. Janke said it. I was going to say education and public awareness, but it was said. I was going to go the route of some legislation. Listen, I'm going to just close by advocating, but ditto, and saying we need, I'll put on my hat, a research and data framework as well. This is going to be the underpinning of what we do. We need to be coordinated in that respect. This is going to be critical within this Jamaican framework and across the Caribbean.
Thank you so much, Prof. And as the CEO of JET comes forward to make the final remarks, I just want to remind you, if you're watching online, please complete the evaluation survey. There's a link that's been sent in the Zoom and the YouTube chat. If you're here in the room, there's a QR code on your table. You can just scan it and complete the survey. Or if you absolutely don't want to do that, there are some physical forms that are available as well. So thank you all so very much for coming. I think it's been an absolutely fantastic morning, and we appreciate your presence, your interest, and your participation.
Thanks, Dion. And thank you so much for an amazing morning. Today has been filled with enriching and insightful discussions. So many things written down. I have my paper written all over the place. Miss Janke, our esteemed keynote speaker, you really set the stage for today's discussion. Thank you. Panelists, Dr. Barnett, Professor Taylor, Mrs. Andrade Goff, thank you for sharing your knowledge and perspectives on the critical issues that we discussed today. Your contributions have really enriched our discussions and deepened our commitment to addressing the climate crisis. Moderator, Mrs. Jackson Miller, you skillfully guided our conversations, ensuring that all the voices were heard and you kept us on course. Your facilitation was instrumental in making this seminar a success, and we truly appreciate it. Specially invited guests and participants, you made today special. Whether you were here physically or virtually, we appreciate you taking the time to be with us and for contributing to the vibrant exchange of ideas and discussions. Our sincere appreciation to Senator Samuda. His presence today speaks to his personal commitment to the environment and underscores the government's dedication to tackling the climate crisis and advancing climate justice in Jamaica. Importantly, we extend our heartfelt gratitude to our project donors, Open Society's Foundation and True Cost Initiative, for their generous support. They made this seminar possible. As you heard, this is one of 4. Your investment in climate action is paving the way for a more sustainable and just future. Thank you. I also want to say a big thank you to the JET team, who you should see. Janelle, Justin, Courtney. A lot of you interacted with Courtney, please. Thank you. This wouldn't have been possible without your support. Courtney Dixon, our legal officer, pulling this event together has largely been on your shoulders. I don't see her. Oh, yes. You did an awesome job. Finally, we thank Turnover for hosting this event and their staff for their service today. Together, we have taken a step in our collective efforts to address the climate crisis, and this seminar marks the first of 4 to be held over the next year and a half. So we hope to continue these discussions as we work towards a more resilient and sustainable future for Jamaica and the planet. Thank you, and have a great weekend. And enjoy lunch.